All right, welcome everyone. Appreciate everyone coming here in person and those joining via the webinar. I'm George Constantine. I'm chair of the Nonprofit Organizations Practice Group here at Venable. And welcome to today's session, which is Nonprofit Chapters and Sections, Animating Component Activities While Managing Legal Risk. This happens to be our first return to in-person lunches for these events. We're really excited to welcome those of you who are here to the office on this rainy Washington, D.C. day. I was looking back and seeing when our last in-person program was, and it was almost exactly 2 years ago, which might not be a surprise. It was on March 12th, 2020, and it was entitled COVID-19, What Your Nonprofit Needs to Know. Now, I'm sure we covered all of the right points, and I'm sure we hit. If we were to look back at that recording, we would have predicted 2 years of this and you know all the hybrid things that were going on and the working from home. But anyway, again, really excited to be able to welcome you here in person. We have we're going to keep doing this in person, and next month we have one which we'll see at the end of the program with the date on international legal activities, really focused there on some of the sanctions issues that are going on that may affect your association or other nonprofit organization operating overseas. But for today, we have a pair of speakers I'd like to introduce. I'm the moderator for today's session. We have a couple of Venable attorneys who have been colleagues of mine for a number of years, and both are identified as rising stars by various publications. But to my immediate left is Andrew Steinberg. Andrew is a senior associate here in the practice and has worked exclusively on nonprofit organizations for all of his time here since coming out of law school at William and Mary School of Law. Also a undergrad at University of Maryland, go Terps. He's been recognized as a rising star by the National Law Journal last year. So glad to have Andrew contribute. And then next to Andrew is Judith Kim, who is a counsel here in the nonprofit organizations practice and works exclusively on nonprofit organization issues like the ones we're going to talk about today. Graduate of Boston University School of Law. Also a rising star, this one recognized by super lawyers. So we have a couple of stars here. You know, working with chapters is a challenge. In my many years of working with nonprofit organizations, for many of our clients, it's quite possibly the number one challenge. On the one hand, chapters are tremendous sources of vibrancy for the organization. They serve as a proving ground for new leaders for your organization, and they help develop membership because you have that local connectivity. If you're a membership organization, but managing them from the national perspective is often very time consuming. I don't have to tell you, it also involves some legal and tax risks as well. So what we're hoping to do today is go over not just those legal and tax risks, but address some pointers for you know perhaps managing chapters more effectively and efficiently, and would certainly welcome your questions along the way as well. I think with that, I'll move on to our next slide and turn it over to Judith to get started.
Thanks, George. Can everybody hear me? Okay, great. So I'm going to just first start off just doing an overview of what we're going to be talking about today. And where I'm going to start us off is really reasons why you may want to create chapters for your organization. And when I talk about chapters, what I really mean are sort of subgroups of your members, of volunteers or different kinds of participants in your organization who are engaging in activities on a local level. And just once we go over sort of the, you know, just the reasons why you may want to create it, I'll talk about the different kinds of organizational types that a chapter can take and how that impacts the relationship between chapters and the national organization, what we'll be calling national organization, which is the main organization. And then I'll go through some just legal pitfalls, and pitfall sounds ominous, but really just some considerations for you to keep in mind that are specific to chapters and their relationships with the national organization. And then I'll turn it over to Andrew, who will talk about tax issues that are sort of specific to chapters and national organization. And then once we scare you or bore you with all the legal and tax considerations, we'll talk about, you know, solutions, right? Practical tips and what we've seen as best practices. In our practice, collectively, we've worked with a lot of organizations that have chapters and talking about, you know, what we recommend at a minimum that you have with your chapters to manage risk and but also to maintain a really healthy relationship with your chapters. And then some practical tips that we've seen along the way.
And I'll just add, we are going to be focusing mostly on US-based chapters. We will, if we do have some time, I'll have a few thoughts on international chapters, which carry with it some unique issues. But I think next month's seminar will also talk a little bit about that as well.
So just to set the stage about terminology, when I talk about chapters, I recognize that some organizations call them sections, regions, areas. We're really talking about essentially the same thing. There isn't much of a difference just because of how you're talking about it. And when I say national, I mean the main organization. I do also want to pause and just recognize that organizations like yours have, different kinds of affiliated organizations that are not chapters. They may have, different purposes, sort of a specific purpose, like, you're holding land for particular property, or they may have different taxum status or even maybe taxable organizations. But we thought that because we have a lot to share on the sections and the chapters that we thought we'd just sort of save that for a different day. And so, what are some reasons that you may want to form chapters if you haven't already? I think I see many of you here who already have experience with chapters, so I know that I'm speaking to the choir about the fact that it does just take a lot of resources. But there are some really good business reasons to do so. And I think the main one is just member engagement on a local level. I think we're just talking about the fact that people are really excited to come back in person and meet people, and having chapters really provides additional opportunities for members to really engage on a local level, establish more deep personal relationships with people who may be facing the same sort of situations that may really exist more on a local level. And so, and that provides enhancement in terms of the member benefits that you get from the national organization. It also provides opportunities for sponsors, for outside companies and other potential stakeholders to engage with the organization and who may just be interested in providing sponsorships on the local level. And then it also provides really a pipeline for national leadership. A lot of organizations that I see with chapters, a lot of them start people who are on the national level who are leaders. They've really started on the chapter level and really develop their skills, understand the organization, and get to meet people along the way, and they go up to the national leadership eventually. And so before I go into this range of organizational types that a chapter can take, it's really a little bit of a balance between, control and autonomy. If you go to the next slide, control, what I mean by control, it's really the national organization that has control over, the chapter's activities. And that's essentially, honestly, to protect the national organization and also to protect the chapters. But then on the flip side, if you go to the next slide, you want to provide a level of autonomy to chapters, right? You want to provide them sort of ownership over the local chapter's activities so that they can really run with ideas and spur innovation and just creativity and on the local level. And so there's really a balancing act that happens that really does need to happen based on sort of the organizational type that you take. So if you go to the...
And even, I would just say, in addition, sometimes within the same organization, it's different chapters require or should have different levels of control or autonomy. And that's often the biggest challenge, is how do you try to do a one size fits all approach when you've got so many different, big chapters, small chapters that need you, big chapters that want more autonomy. So I don't know that we have a solution for that. I'm just pointing.
No, it's a challenge that we're highlighting.
Next.
Yeah. So here's the continuum, and to simplify things, on the left-hand side, you see, what we're going to call for this presentation fully integrated chapters. What I mean by that are chapters that are essentially, they have their own name, right? They're saying the New England chapter for an X organization, but in the background, in the contracts, in their bank accounts, they're using the name of the national organization. They're using the EIN, most importantly, of the national organization to operate their activities. And so I don't think fully integrated chapters appreciate being called sort of programs of the national organization, but they are components of the national organization. And on the flip side, when you look at the most right hand, you have chapters that are independently incorporated. They have their own separate EIN. They've got a board of directors. And hopefully, Andrew will highlight some of it. They have their independent tax-exempt status and are maintaining it well. In the middle, we have unincorporated chapters, and I'm not suggesting that it's really the best compromise position, and for reasons that I'll highlight a little bit later. But unincorporated chapters they have separate legal existence, but they haven't just gone past the last step of incorporating it and creating a corporation. And I have on this slide that chapters sometimes rely on the national organization for many of their services. Not suggesting that's a hard and fast rule for unincorporated unincorporated chapters, but they tend to, I've seen unincorporated chapters that are just smaller, have less resources. They tend to rely on the national organization for a lot of their support, and that creates some risk implications for the national organization that I'll highlight in a future slide. So what does the relationship look like with a national organization depending on the organizational type that you have? When you are a fully integrated and chapters within the national organization, yes, they're, again, like I said, they're the New England chapter of X, but they are really essentially operating as part of the national organization. So ideally, when you talk about rules of the road that you want to set with your chapters, you want to see them in sort of a policies and procedures that's approved by the national organization, as well as, sometimes chapters are referenced in the national organization's articles and bylaws as well. I think, sometimes I recommend just to set expectations with chapter leaders to, have them review the policies and procedures and perhaps even sign a form or a more formal agreement, just indicating that they understand that there are rules and that they agree to follow them, just to sort of set expectations, but also to manage the chapter activities. I think ideally, honestly, from a legal standpoint, you have 100% control over these chapters in the sense that they are part of your organization. So at the end of the day, if there's a disagreement between chapters and the national organization still controls. But practically speaking, I recognize that that's not sometimes reflective of reality, especially if you have very active chapters that do a lot of activities. They may not run them through the national organization. And that creates some challenges that I'll highlight later.
Right. And I think also on the fully integrated side, I've seen situations where some of our client organizations will have chapters that are within the corporate umbrella of national, but there's a setup where they actually have a dedicated fund for the revenue that they help bring in. Maybe it's allocated based on members in the area or allocated based on revenue brought in from chapter events and things like that. So there also could be, even within a fully integrated situation, some level of almost restriction placed on your funds that you have based on the chapters that brought it in.
So for unincorporated chapters, they have separate legal existence. And so ideally what we like to see are, at least at a minimum, some kind of charter. And what I mean by charter is a document where the national organization is granting permission for that chapter to engage in certain activities within a particular geographic area. And so, and I'll highlight later about sort of the importance of that and the reasons for it. But then sometimes the charter is sort of embedded into an affiliation agreement with your chapters that covers and addresses a lot of the legal risks that we're going to be talking about in a few slides. And then for incorporated chapters, there's just an additional set of documents. They have their own articles and bylaws. And so you may want to consider, what kind of rules and standards that you want to put in place to make sure that your chapters are being consistent with their nonprofit and their tax-exempt status, but also to have some level of consistency among your sections. So I'm going to talk about legal risks in the next slide, but honestly, it really comes down to liability. I think the main concern from a national organization's perspective is how much is the national organization going to be liable or responsible for any kind of injuries or other kind of claims that come in for chapter activities. And so when you're in a fully integrated chapter, they're 100% liable, right? You are one organization. And I think one of the biggest areas that I see this being played out and having issues is when typically with chapters, they're often run by volunteers, and it's not their full-time job to really oversee and manage, planning events. And so they sign documents, they try to push things out, and they aren't taking a close look at, the fine print, the terms and conditions, or they don't even know that it's a contract that they're signing. And then it eventually flows up to the national organization staff that, oops, I signed something that's going to be problematic. It may create obligations that essentially come back to the national organization since they are part of the same organization. And so setting rules, setting expectations of when the chapters needs to go back to the national organization for permission or for approval, that's just something to keep in mind if you have fully integrated chapters.
And we're going to talk a lot more about some of the strategies to manage those risks. But having a key point person who is strong on national to address chapter issues and make sure the rules are enforced is very important for when you're fully on the hook.
Right. For unincorporated chapters, they are separate legal entities for all intents and purposes. And so the national organization should not be as liable as if they were fully integrated into your chapters. I think it does depend on the level of interaction and support that the national organization provides. If the national organization is essentially running it like another program of the national organization, there may be an argument for plaintiffs that, look, you're the same organization, so the national organization should be liable. I think also a disadvantage with unincorporated chapters is that directors, officers, and even members or other leaders of chapters can be personally liable for activities that are happening on the chapter level. And so when I talk about the middle ground, it's not really perhaps the best compromise position. This is what I'm talking about. You've got exposure of liability on both ends for the national organization as well as for the individual members who are participating and volunteering their time mostly for the chapters.
Yeah, I think almost practically speaking, national should almost view itself as on the hook, just because are they really going to let their individual leaders be the ones who have to pay the damages in the lawsuit or the damages for a breach contract? So yeah, I feel like that middle ground is sort of no man's land where no one should be.
Yeah, I cringe sometimes when I first learned about an organization having unincorporated chapters. I just put my my hands in my head and things like that. For incorporated chapters, you do have a shield, right? They are a separate corporation. They've gone ahead and filed incorporation papers, and by having a corporation, your directors and officers are mostly, not personally liable for the activities of the chapters. I think there's a fancy term called piercing the corporate veil. It's an exception to the rule when where the national organization is essentially running the chapter activities. You commingle funds, you have the same staff. I mean, things that you wouldn't ordinarily do if you are separate entities. If you're doing that, then that may create liability for the national organization. But as long as you're sort of respecting those corporate formalities, making sure you've got separate board meetings, things like that, you should be pretty shielded from the liabilities of the chapters. So when I talk about liability, I think the first thing that I have in mind, and probably for you too, is slip and falls, right? Injuries and accidents that are happening, particularly at your events. But I do want to highlight that there are other kinds of liabilities, like I previewed a little bit earlier. Breaching a contract is another one. I think especially in this COVID times, there were a lot of situations where chapters may needed to have canceled their meetings, and there were lots of cancellation fees that are especially put into hotel contracts. So you just need to keep in mind, and that also creates liability for the chapter, and where the chapters may not have enough funds to be able to cover for that. And then intellectual property infringement. I think for us millennials, we understand that sharing music on Napster is not kosher, probably not really appropriate. But I think for most people, they don't really think about, IP infringement as things like where you're copying pictures from a website and putting it on events. Or even if you're streaming music from Spotify, if you're having them at a chapter event, that also could create issues and claims of copyright infringement. And so those are just things to keep in mind, and that may create liability for the sections, and that may sort of rise up to the national level too.
Yeah, and I would say it wouldn't go to create much risk on the piercing the corporate veil front, even if you establish good standards and enforce them with separately incorporated chapters to say, here's the process you need to go through before you sign a contract, or here's the steps you should take to minimize risks of injury, for instance. Maybe it's the right insurance coverage. It's making sure you have a qualified bartender if they're serving alcohol and those sorts of things. Those sort of common sense protective measures will help a lot to not so much avoid liability flowing to national, but avoid liability altogether.
Right.
Am I moving on to the next?
Yes. So this is sort of a slide put in a different way in terms of the different kinds of ways that the national organization can be liable for the chapter's activities. And so and this really depends again on where you are in the spectrum of your chapters. If they're fully incorporated, if they're fully integrated into your national organization, you're going to be liable. For unincorporated chapters, there may be some liability like we discussed. And then sort of on the other end, if you have separately incorporated chapters, you're good as long as you sort of just be mindful of the level of control that you're exercising over the chapters. I've had conversations with associations where we talk about, well, how much do you really want to get involved with sort of the nitty-gritty day-to-day activities of what they're doing, and sort of potentially exposing the national organization to risk if the national organization is really directing the activities of the chapter. That's just something to keep in mind. for even if you have sort of this extra protection by having separately incorporated chapters. So besides liability, I think the second area of concern that I have, and I often see this as well with organizations where chapters often tend to use the national organization's name and logo. And I get that the national organization, they have perhaps informal relationships with their chapters and they're on friendly terms. And so I've seen a lot of organizations don't have a formal license agreement where the national organization is essentially licensing the name and logo, but also having the right to yank that away if they're not using the name and logo in sort of in the proper manner. And this doesn't really come up to be an issue when you're friendly with your chapters. The chapters are following all your rules. Everybody's really a great big family. But it does become an issue if you don't have an agreement, you haven't really been policing your trademark use by the chapters, and the chapter wants to disaffiliate with the national organization, or they're causing a lot of trouble and you want to disaffiliate with them, but they still want to use the national organization's name and logo, since understandably the national organization's trademarks have a lot more value than perhaps the chapter level branding. And so there's a fancy word called naked licensing that comes up where if you don't have a written agreement, if you haven't been policing it, there is a chance that the national organization can lose the right to be able to protect its trademarks and be able to say, no, you can't use it because we're going to yank your license away. And so I think it's important at a minimum. I talked about the charter. The second document that I ideally like to see is having some level of license. It could be in the same document, but having that license and the ability to be able to control and police the use of the trademarks.
Yeah, for so many organizations, that's the one hammer that national wields to keep the chapters in line. Obviously there's the flow of revenue too that we can talk about, but clearly that protection of that name and logo is key. And there was a dispute some years ago in the state of Washington involving a large national charity whose name escapes me now, where that was it. The Washington state chapter had the name of the charity, and there was strong position that the Washington chapter had that it had attained rights to keep the name even after disaffiliation for that very reason.
And that's not ideal, obviously, for a lot of different reasons, but for nothing else, but you want to protect the reputation that's associated with the trademarks. And so you definitely want to keep that in mind. Publications and data, there's IP that floats around, that's national organizations ownership. But I think where you are creating IP together with your chapters, the main thing is just establishing who owns it. And if another organization wants to, if the chapter or the national organization wants to use it, having a license to be able to do that and just clarifying that in a document would be great. And then I know that the title of this slide is governance challenges, but I do just want to highlight that they're really just topics of discussion that you really want to have with your chapters of, how is this relationship going to work? And so for organizations that are interested in creating chapters, this just really is a laundry list of things that you really do want to hammer out. I think, mainly, I think the biggest interest is really on money, right? Where's the money going to come from? How can you use the money? Especially if you've got separate bank accounts, this is just something that they're really interested in. And there's other controls in here that we'll talk about later about addressing specific legal issues that are going to come up. But just wanted to provide this to you in case you are considering either forming chapters, or if you want to do a refresh on your relationship with chapters. Talking through having these conversations about these topics is important.
I'll just pull two out now real quick, just to talk about briefly, just in my experience. You see the board engagement bullet with lack of turnover in board. That is constantly an issue with chapters that, at least with our clients we work with, where there are some real powerful personalities in a particular jurisdiction who over the years have just felt it was almost their right to be the president or the chair or whatever the title might be of the chapter. And, there's some good to that, right? You've got somebody with energy who really has sort of belief in this organization and is carrying it through. And oftentimes it's difficult to get leaders to step up at a chapter level. But that issue very frequently gives rise to governance and sort of relationship headaches with national, because oftentimes people in that role start to feel they have more power than they actually do. In addition, it hits that last bullet point, internal controls, pretty hard. If the chapter is separately incorporated, has its own bank account, and it's the same person with the authority to sign over years and years and years, it is just a recipe for disaster on potential embezzlement front. And if you look and see reports on, nonprofit embezzlement and issues related to that, very often it's someone in that same role for years and years and years without much oversight, that after years and years and years, others are just trusting that this person's doing right by them. So all of these are things to think about. And we're going to talk about how to implement training to help chapters sort of be more compliant with these issues. But in case we miss it later, I wanted to bring that up.
So now I'm turn it over to Andrew to talk about tax issues.
Sure. And just to add on, George, what you were saying as well, the governance issues and just good corporate housekeeping becomes important. There's been a trend with chapters, maybe their interest is too small and they combine, and you have to look at how are each of the two chapters operated, how are they organized, and that's also part of this equation. But anyways, moving into the tax exemption side of things. So this part of the discussion applies to chapters that are separately incorporated. Is that good? Better? Okay, great. So this applies to chapters or sections or regions that have their own separate EIN, they're a separate incorporated entity, or they're an unincorporated association. And just like the parent organization, they should be mindful of the sources of their tax exemption, both federally from the Internal Revenue Service, and that can be obtained through an individual application to the IRS, just like any other organization would approach the IRS to be independently recognized, or through a group exemption process, which is, and we'll talk more about this, but it's essentially a regime in which the IRS deputizes a pre-existing organization to stand in the shoes of the IRS as an administrative convenience to approve tax exempt status for chapters and sections that are related to that parent organization. And it's a great and effective way, both for the IRS in terms of processing volume, it doesn't have to process as many applications, and also an easy, convenient way for central organizations to create new chapters relatively efficiently. On the state level, depending on where you are, you either have to go to the state taxing authority to get recognition of exemption for a chapter, or just automatically granted on the basis of the federal exemption. So, for example, in Delaware, which is a popular jurisdiction of formation for for-profit companies and nonprofit companies, when you incorporate a tax-exempt non-stock corporation, that entity is exempt from Delaware taxes. So there's no separate application that's required. That's it. In the District of Columbia, you have to go to the Office of Tax and Revenue. Same thing in California, New York, where you have to affirmatively go to that state taxing authority to get recognition of that state income tax exemption, even if the IRS has an exemption in place for your organization. And additionally, with state level exemptions, there are other types of taxes that exempt chapters might be entitled to obtain exemption of. So that includes state property tax or state sales and use taxes. It really depends on the jurisdiction. I think what's important is that not all types of tax exempt entities are eligible for state level exemptions. So for example, some states might allow all Section 501c3 organizations to have some form of entitlement to a sales and use tax exemption, and that's on paying sales and use tax on purchases of items. Here in the district, for example, that exemption is far more narrowly construed, and only certain types of C3 entities are eligible for exemption. So it really depends on the state. It's important to check. But I think this also ties into, from a management perspective, looking at, if you're forming a new chapter, where do you want to form that chapter? And you might form it in a place that's different than where that chapter's activities are actually conducted, to minimize some of the administrative burdens that come out of having to manage, competing sources of tax rules for all of your chapters, as well as multiple levels of tax exemption for chapters. And the last point I'd note on this is just some states are different about renewal of tax exemption requirements. And so some states, once you have it, it's in effect until it's revoked. In other states, you have to renew it every 3 years or 5 years, and if you don't, you lose it.
On the next.
Yeah, on to the next. So as I mentioned about the group exemption process, it's for closely related organizations, and this has been a process that's been taken advantage of by over 4,000 organizations, and there are 400,000 subordinate organizations that fit on a group exemption process. And the way in which a subordinate organization is added to a group exemption, they go to the parent organization that's already obtained authorization from the IRS to bestow tax exemption. They have to review the governance documents of the chapter organization, and they have to ensure that they're going to be in a position to exercise supervision and control over that subordinate organization, and have an affirmation from the subordinate organization that they want to be added. And the way in which that exemption is documented for the subordinate organization is the parent organization has a letter from the IRS that says, you're a group exemption holder, you can recognize groups as exempt under your tax exemption status. And then the parent organization issues a letter to the subordinate organization that says, you're included on our group exemption. And normally there's a 4-digit number that's associated with the group exemption number that's included on the returns for subordinate organizations and is referenced in exemption applications, either federally if there's a reinstatement issue, or at the state level when you have to evidence that exemption. Group exemptions are really helpful for existing organizations that have one, but they're on pause right now. The IRS proposed in a notice to update its procedures for group exemption issuance, as well as the rules for subordinates. And that update was, I guess, 40 years later. So it's been 2 years, but there's been no issuance of final rules. So anyone who doesn't have a group exemption ruling in place can't get one. The IRS is not accepting applications, but if you have one, you can keep using it and you can keep adding organizations to it.
Yeah, and Andrew would talk a little bit more about what the proposed environment looks like, should it ever come to being. But the IRS has had, this has been, I think, an area of frustration for the IRS for a number of years, in that it's, as you can see, if you're viewing it from a regulator standpoint, it's very difficult to regulate when you've basically deputized each national organization who holds the group exemption to look out and make sure that these others qualify. But the sort of the cat's out of the bag. As Andrew pointed out, the numbers, and so many of the group exemption holders are very large church organizations, large recognized charities. So they're not going to pull it back in. We'll talk a little bit about what the new regime might look like. Suffice to say, and you'll see that it's more strict. It'll be a little more difficult to get in under the group exemption process under the new rules.
Right. And maybe that weighs in favor of a chapter going to the IRS on their own for exemption status. All the applications are filed electronically now on pay.gov, so that adds an extra hurdle for a national organization to walk through a chapter, through the process of applying on their own. But the key points about the independent recognition are that the IRS issues a specific determination to that chapter organization that you are exempt from federal income tax under section 501c3 of the code, or 501c6 or 501c4, depending on their activities. So charities and trade associations, C6, and social welfare organizations, C4. For C3 status, you have to apply to the IRS for recognition in virtually all cases. For 501c6 organizations, it's optional to apply. An organization can say, we're 501c6. However, sometimes to get entitlement to a state tax exemption, you have to have a determination letter from the IRS. So it can foreclose the option to self-declare depending on where the activities of the organization are located. And sometimes donors will want to see an IRS determination letter as well, just for comfort and assurance that there's a federal government agency that's recognized the organization.
Yeah, and it's been, that's an issue with group exemptions that comes up again and again. For those nationals that hold group exemptions, that let their chapters in under the group exemption, they don't have their individual letter. And if it is a C3 and they want to collect charitable contributions, or they want to solicit a private foundation for contributions, oftentimes the donors in those situations won't go ahead with the gift if there is no letter that shows the name of that organization. Some try to get by with a letter from the national saying, trust us, there's a group exemption, this one's a part of it. But that independent letter, particularly for C3s, is real important.
Mm-hmm. Yeah, next slide. So what are some changes to the group exemption processes of late? The IRS has been looking at updating and overhauling, and I think perhaps simplifying how the process works. So in the past, the IRS would generate on this roster that would go to every parent organization that had a group exemption, this roster of called the list of parent and subsidiary accounts, and organizations would have to mark by hand changes to that list, to the name, address, EIN, corrections, additions, deletions, and send it back to the IRS. The IRS has eliminated that list. They will no longer issue a list, and instead they've placed the burden and the responsibility of management of the roster of the group exemption on the central organization itself. And so each year, this is an annual reporting requirement, a central organization has to send an update to the IRS at least 90 days before the end of its fiscal year. So not after, but before. So it's an odd timing on reporting. They have to identify if there's been any changes in the purposes of, or the composition or the structure of their subordinate organizations, changes in name, changes in address, who's been added, who's been removed. And the failure to send that list to the IRS can result in the revocation of the group exemption ruling. So it's very important to, one, be timely with the submission of the annual roster, but two, have proof that it's been sent to the IRS as well, and to retain proof of mailing. In the proposed new requirements, there is some relief to change the time period for providing that information update from 90 days before the end of the fiscal year to 30 days before the end of a fiscal year. So for calendar year filers, it's going to be about December time, and for July to June filers around May, end of May. And working backward from there about soliciting information and updates from your subordinate organizations becomes particularly important. But as far as what the new requirements are, and this came out in Notice 2020-36 about what the IRS is thinking about changing in the group exemption program. It's in part, I think, one, to ensure that central organizations are taking a more active role in being a deputy for the IRS, and not only at the outset of recognizing a subordinate to be added to the group exemption, but ongoing compliance and requirements. So some of the changes are that in order to be a group exemption holder, you have to have at least 5 subordinate organizations. You're only going to be able to have one group exemption ruling, as opposed to being able to hold different group exemption rulings that have different subordinates. There's a new matching requirement for 501c status as well as public charity status. So all of the subordinates have to not only be of the same 501c designation, but they have to be of the same public charity status type as well, which can be important depending on the nature of the operations of the underlying subordinate organization. There's also a requirement for the subordinates to have similar purposes, and that's being measured based on the National Taxonomy of Exempt Entities Classification Codes, which is essentially a directory of 400 codes that groups nonprofit organizations into different industry categories. And so at the outset, and looking at subordinate organizations who might be added, or your existing set, there might have to be a classification exercise of going through and identifying the activities of each organization. There's also going to be a requirement for uniform governing instruments and documents. And I think the takeaway there is having templates. Having templates for your articles of incorporation, your bylaws, other key policies. And I think that's also part of the consideration for if we do have separately incorporated chapters, should those chapters be incorporated all where the central organization is incorporated for easier management purposes, just because we're all operating under the same governing law? Or should those chapters be incorporated where they're located? And sometimes it can even be difficult to determine where a chapter should be incorporated if it's not operating under geographic boundaries of a state. Sometimes chapters span regions, and so that can be difficult as well. And then the last piece of the requirements are the ability to actually remove and kick off a subordinate organization. And another point to make as well is that currently, central organization has to maintain supervision or control over their subordinate organizations. And what that is has not been defined yet to date. And the new regulations propose a definition that would apply to new group exemption holders. That's essentially, I think, a codification of what actual practices are. But that supervision requirement requiring the subordinate to annually report each year for purposes of completing the IRS roster, as well as providing evidence of the Form 990 filing that has been made, as well as the central organization educating the subordinate organization about their tax exempt status compliance obligations, including the obligation to file their own Form 990 return or to be included on a group return. So this is all based on proposed rules. It's been 2 years. Maybe there'll be an update this year, hopefully, maybe next year.
It's also notable that if you have a group exemption now, some of these new rules, you're going to be grandfathered away from some of these new rules, but not all of them. Some of them will apply to the old group exemptions as well. So
That's right.
but right. So you
And some of the rules under the grandfathering rules as well may only also apply to grandfathering of subordinates that are already on the group exemption. So some of these new requirements will have to be introduced for new chapters that are being that are going to be added. So stay tuned on what the IRS ultimately decides. So as far as tax reporting, virtually all types of tax exempt entities have a filing obligation. The Form 990 is the primary return that's filed with the IRS. That now has to be electronically filed. And some states require their own version of the Form 990, their own state form, or the filing of the IRS Form 990 with that state. In addition, with state income tax, there can be an obligation just like federally if there's unrelated business income tax that's reported by a chapter for that chapter to report it both to the IRS as well as to the state. So that's also something that should be kept in mind as part of the filing obligations. I think it sounds handy, but is more complex is the ability for a parent organization to file a consolidated group return for its subordinate organizations. A parent organization can get a special EIN code for a group return and file a separate Form 990 for some or all of the subordinate organizations on its roster. And if that filing is made, it then removes the obligation of the subordinate organization to make its own independent filing. The alternative is each subordinate files on their own and they're responsible for filing and should ideally provide a copy of their return to the national organization. One of the challenges about the former and doing the group return is the diligence that's required and the level of assurance that's required about the financial state of the chapters and having to file return under penalties of perjury. And so for that reason, and because of the lack of visibility, the lack of control over bank accounts and the books, parent organizations will choose to have the subordinate organizations file their own Form 990 return.
Right. So to reemphasize something Andrew already said, which is real important, is just because a chapter's on a group exemption doesn't mean that they're free of their independent Form 990 filing, unless there is this group return option, which, as Andrew noted, is not taken advantage of very often for the reasons you stated. So, as Andrew's going to say, when it comes to automatic revocation of exempt organizations, when the IRS first embarked on, or the rule first changed, when the tax code changed to allow for automatic revocation of exempt organizations who have failed to file for 3 prior years, that first list of automatic revocations that came out, I don't know, it was like 2015 or something like that, was almost, well, not all, but was littered with chapters. That's where the compliance was falling down, as chapters weren't filing their Form 990. So.
Yeah, and we're starting to see chapters that have been revoked before get revoked again because it's been a few years, so that always keeps it interesting. But the filing dates are very important, and it's important to remind chapter organizations about their filing deadlines, because if they miss 3 years in a row, they will lose their group exemption status. And once they're revoked automatically, they can't get added back to the group exemption. So then they're forced to go independently to the IRS and incur the application fee and the processing time and the questions, and they lose essentially the benefits of being on the group exemption. And also another reason against the group returns, if the parent organization fails to file those returns for 3 years in a row, all the subordinate organizations lose their group exempt status, and I'm sure no parent organization wants to be have put in the position of a mea culpa to potentially hundreds of chapters and organizations.
Just as a practical note, the IRS sometimes doesn't actually receive, or they claim that they haven't received certain documents. And so there've been, especially with the pandemic times, there've been instances where they've come to us and said, look, the IRS has sent us a notice saying that we haven't filed a 990. And the backup documentation is going to be important. The IRS is not going to take your word at it saying, no, we promise that we gave it to you. You need backup. And so getting, from a national organization perspective, making sure that you are sending any kind of IRS documentation, especially including the group information notice that you have to put in every year with a return request or whatever kind of way to confirm delivery and keep that in your records. And then also having your chapters provide any kind of 990s or things, including with the return receipt, and having those on record so that if chapters get into problems, if the national organization gets into problems, you have those on record in a central place so that you can sort of address those problems in advance. And requiring this kind of annual reporting where the chapters give all these kind of documentations to you will help you monitor whether or not they really are filing their 990s.
Yeah, and for organizations that are new, there have been some challenges with IRS databases in the EIN. And now that all 990s have to be electronically filed, some organizations have been prevented from filing their Form 990s on a timely basis. So just document everything that occurs with the filing process and keep a record of it so that if and when, and most likely when, the IRS comes along to claim some type of late filing penalty for the return, there's a documentation that can be sent back to the IRS to show that this late filing was not the result of the organization's fault. And that sort of plays into the reinstatement process as well as to the types of reinstatement procedures that the IRS offers for exempt organizations and the level of proof that an organization has to include in its submission to be entitled to reinstatement of its status. So there's a streamlined process for small organizations that are eligible to either file the 990EZ return or the 990N return. And so those are organizations that either have revenues that are less than $50,000 or less than $200,000 and assets that are less than $500,000. They can't have lost their status before, and they need to submit the reinstatement application and the past due EZ returns, if applicable, within 15 months of appearing on the IRS's revocation list. Any 990Ns, you can't late file them, so they're just excused from filing. And the IRS, in that case, essentially deems the organization to have reasonable cause to get reinstated back to the date that the exemption was lost. So essentially, there's no lapse in status, even though there was some period of time in which the IRS removed the organization from the list. And so having that evidence of reinstatement can be really important, especially for financial transactions that occur in between the period of the revocation date to the date that the IRS informs the organization, congratulations, you've been reinstated, because that period, it could be over a year sometimes.
Yeah, often.
And then for larger organizations, there's a retroactive reinstatement process, but it's a bit more laborious. You have to submit a new IRS application for your type of tax exempt status, and you have to establish a reasonable cause for the failure to file the returns on a timely basis. And depending on when you seek reinstatement, affects the basis on which you have to show reasonable cause. So if you get to your reinstatement application within 15 months of being revoked, you just have to show that we had reasonable cause for not filing in one of the 3 years. If you're after that 15-month mark, you have to demonstrate all 3 years there's reasonable cause for failure to file. And that can be difficult depending on the facts and circumstances. And what I mean by reasonable cause, it's the exercise of ordinary care and business prudence. And so the IRS requires a description of the full set of circumstances that prevented the organization from timely filing, how the organization discovered that it didn't timely file, and what corrective action has been taken to prevent or mitigate a filing error from occurring in the future. And then for the application date reinstatement, that essentially, you're not getting retroactive reinstatement. You're just going to be recognized from the period on which you submit your application for renewal to the IRS. So the takeaway, try to get retroactive reinstatement if you can, and try to do it quickly. And a great way that national organizations can help their subordinates, have template forms available, have a summary of the application process. Here's how you go back to the IRS on your own to do it, or help facilitate the reinstatement application yourself.
Right. And to avoid being in that situation, send good reminders at a regular basis to your chapters and subordinates to make sure they're filing their 990 regularly. Okay.
So I'm not sure if we've bored you or scared you with all of these legal and tax considerations, but we did want to spend some time talking about what we think are our best practices and recommendations. And if you haven't caught on by now, we recommend putting things in writing. And before I go into this laundry list of items, I do want to recognize that, especially if you have an organization that already has existing chapters, you've been working with chapters very well in the past, and then you suddenly introduce this concept of an affiliation agreement or a charter, it may create tension. Chapters are going to push back saying, why are you suddenly giving us all these requirements or expectations when we've been working so well in the past? And I think the one thing I just want to say is that we recognize that. We want this to be a process that helps manage risk and manage all the things that we've just talked about, but also it helps the chapters in the long run. It'll help manage risk. It'll help sort of flag things like if you're failing to file, making sure you catch that early on so you don't have to go back to the IRS for reinstatement of your tax exemption. And so and ultimately it really does help spur conversations with your chapters. Look, at the end of the day, managing risk is great, but the main goal of having chapters is really to have good relationships with the local level and making sure that they are spurring activities for you on the local level, as well as encouraging engagement on the national level as well. And so it may be difficult in the beginning, especially if you're introducing one sort of in the middle of your relationship, but I found that having these kinds of discussions helps facilitate sort of a better long-term relationship with your chapters. So with that, what kind of things should we put in a document? I think, like I talked about, the first document or concept that I think would be that I would recommend is really a charter. I think establishing that the national organization is the one that's granting permission for the chapter to engage in particular activities in a designated area, and being able to use the national organization's name and logo associated with that is really important. And I think equally as important as granting the charter is describing the ways that you can terminate that charter. And there's a little bit of, a balancing act of how much discretion that the national organization will have. But at a minimum, you definitely want the national organization to be able to terminate that charter if the chapter is really acting up and they're not, adhering to the responsibilities that's required in the written document or of the rules or the policies and procedures that you have in place, or if they're not really adhering to your responsibilities. And that may include things like, how are you engaging in your activities to sort of manage the reputation of the national organization's name and logo.
And I would say oftentimes the decision to decertify a chapter or remove a charter for a chapter is reserved to the board of the national expressly in the document. And that helps to reassure the chapters a little bit that it's not going to be, one officer or one executive director or CEO who's got issues with a chapter. So oftentimes it's built that way.
Yeah. I think it's also important to set expectations and limitations on what the chapter can do. I think, there are often, here are the things that you can engage in, or there are certain documents, there are certain relationships where you say, look, you can engage in a variety of different activities, but your mission, your purposes, and your activities just can't be inconsistent with the national organization's mission. I think that's important. Just, they're using your name and logo, right? And so just making sure that there isn't really confusion in the marketplace, especially if you have a chapter that's, saying advocating for A, and you have the national organization advocating against A, it just may create some confusion as to what position is actually accurate for the national organization. And so setting that expectation on the forefront helps sort of manage any kind of issues that come up, in the back end. I think it's also important to just talk about and decide on what kind of activities that the national organization and services that they're going to provide support to the chapters. It sort of sets expectations, right? I think if you just say the national organization will support, the chapters in a variety of different ways, it doesn't. People can think of that in different ways, and it creates perhaps different levels of expectation of how much the national organization is going to be supporting the chapters. And I think just being a little bit more specific, right? The kinds of things that the national organization can and is willing to do will help set expectations in the long run.
And in that category too, clear establishment of objective guidelines, if you can, on what when chapter events can be held. Are there dark periods where we're having a national event, or is there a big regional event that happens? Build that into the document, or maybe in the policies. Maybe it's not in your affiliation agreement, but in the policies to make that clear and to avoid that situation where you feel that we're robbing Peter to pay Paul.
The next sort of topic is finances, and what I really mean is money, right? Everybody pays attention when you're talking about the money. Who's going to get it? Chapter activities take resources, especially money, to be able to run. And so if you are going to be sharing revenues with your chapters, and like, for example, there's some national organizations that share a portion of the dues that come in for members to the local level. Well, you should talk about that. How is that going to get to the chapters on the local level? And then also, talk about what are the kinds of ways that a chapter can independently raise revenue, including fundraising opportunities. If you have limitations or concerns on how they're going to do that, you're talking about that before chapters do that, and is going to be helpful, so that you don't have to say, no, you can't do that, and setting up a new rule when they've already started doing that. I think internal controls are important. George alluded to it earlier. I think one of the things that I do want to highlight for chapters that are fully integrated, I've worked with a couple of organizations that have separate chapter bank accounts. It's not just restricted funds on the national level, but they have their own bank accounts. And I think at a minimum, what I would require from the internal controls is requiring for each of those bank accounts to have a national staff member be listed as an authorized signatory on that bank account, and having access from an online standpoint for login, just because since it's a separate bank account for the chapter, but it's using the EIN of the national organization. And so that is those are assets, and those are revenues and expenses that need to be reported on the national organization's financial records. And so it's important for the national organization to know where those assets are, and to be able to reconcile it against their financial documents. I think also another thing is, like George alluded to earlier, they are the national organization's assets, and you have a responsibility as a national organization to manage that. And so monitoring and having access to those bank accounts will help sort of ward off potential embezzlement that's going on the local level, and being able to catch that on the earlier side will be really helpful for the organization. And then talk about trademarks, right? Licensing the name and logo. I think if you're not going to have a full set of documents or have a list of this, the charter and then the license is really going to be important. And setting rules on how chapters can use the trademarks are important. Sometimes chapters like to get creative with the national organization's logo. They like it in blue instead of red. They like a little bit smaller font. They have different ways that they use it in association with their chapter, identification, whether it's on the left side or the right side, or the logo is really small compared with the chapter's name. I think those are things that you do need to set, controls on, and rules specifically on how they can use the name and logo. It's complicated, but I think just generally from a trademark perspective, you do want it to be consistent. Don't allow the change of the name, the color, don't allow size. You have to be pretty specific to make sure that you are properly policing the use of that trademark. I think another sort of aspect is, I talked about IP in general, but I did want to highlight about membership lists. National organizations often allow the chapters to use a portion or the whole membership list. But I think, there are opportunities for, outside parties to pay royalties in exchange for licensing the membership list. And I think it's important for the national organization to really set limits on that, on the front end, again, about how and when they'll be able to do that. Particularly since membership lists, they have personally identifiable information, which implicates federal and state privacy laws. But also there just may already be limitations on when the national organization can use that information, and that needs to be trickled down to the chapters. And so it's just something to keep in mind. Again, you want to set the rules in the beginning so that the expectations are really set in the beginning. And then last, about liability, I've talked about it, but I think from a practical perspective, I think really the best protection against liability is insurance coverage. I think you may have separately incorporated chapters, you may have great controls and policies and procedures, but at the end of the day, if the chapter doesn't have money and the plaintiff really wants that money, the likelihood of them coming after the national organization, who generally has deeper pockets, is higher. And so one of the things that, we can talk about legalese, we can talk about indemnification, ways that you can manage that risk, but it comes down to, as long as a national organization has enough insurance on the chapter level and as well as the national level to be able to cover potential liabilities. That's really the best way to protect both organizations, right? The chapters and the national. And so if the chapters are not able to afford liability coverage or insurance coverage in general, perhaps that just may be something that the national organization may be willing to cover, or if the chapters are able to do so, require them to have insurance coverage.
So when it comes to governing documents, and by governing documents, I mean articles of incorporation or charter and bylaws, it's important to use model forms with explanatory comments that explain what the range of options are, and to require approval from the national organization before there are deviations from that approved template form. The forms themselves should require approval by the national organization to significant corporate events, things such as changing their governance documents, merging with another organization, dissolving, or liquidating and transferring all of their assets to another organization. And depending on where that chapter is located, there may be a need for regulatory approval of those types of transactions as well, typically from the Attorney General's office in a given state. And besides the nuts and bolts of the governance documents themselves, they're often accompanied by explanatory material like a chapter leader toolkit as part of an orientation process. I think that's an important component to this as well, to help explain, here's the full universe of how everything operates together. We have the governance documents, we have tax exemption, here are your filing reminders, here's what you should do to be a good chapter leader and programmer. And I think that helps put everything together in a hopefully digestible and easy way that can be passed down from time to time as leadership changes. And also record keeping is incredibly important. It's important to have a record of the governance documents, the filings, and that should be baked into the full suite of information that's provided.
Yeah, no, I agree 100% on the record keeping point, particularly at national, to keep hold of those and understand where each chapter is in terms of their governing documents and other key documents. If you can do that nationally, that will help a lot in managing risk. Moving on. Okay.
So I think we've covered a lot of these already, but send filing reminders and require periodic reporting by chapter leaders about their organizational changes, both to have good records so you know who you should be in touch with when you need to have outreach with the chapter, but also for a national organization to comply with its own filing requirements. Have a staff where hopefully multiple staff members, if possible, available to guide chapter volunteers and fielding the range of inquiries. I know it's been helpful to maintain a list of the long-running questions that tend to repeat themselves from time to time, right, so that there's a guidebook of, okay, here's a response on this issue, so that when question 1 comes in from chapter A today, and then you get the same question 3 weeks later, there's a standard response that's available to assist. Provide training and orientation, as George mentioned, coordinate your events and conferences to work in harmony with each other, and perhaps most importantly, try to strike the right balance between self-governance, centralization of your activities and affairs, and at the end of the day, bringing people together. I think not losing sight of that. The governance is an important piece, but the organizations exist for a reason, and that's to accomplish a specific purpose or mission or advance a cause.
Yeah, and many groups will have on the training front, as part of their annual meeting or something like that, there will be a day or a half a day for chapter leader training, and maybe it's, if there are staffers, then it would be staff people at the chapters as well as maybe the elected leaders at the chapter level. Sometimes, when I sort of started the program, I talked about chapters being a bit of a challenge, and sometimes those events and those half-day chapter trainings can be a bit of a gripe session. I say, sort of practically speaking, let it happen. Let it play out and let them have their say, understanding that we do have rules in place and we have sort of guidelines. But don't shy away from getting the chapter leaders together because they're going to give you a headache. They may give you a headache, but I think at the end, if you sort of push away on that, you're going to sort of create a bigger headache later on. So, and obviously the training itself is very effective and good to have to make sure they understand their compliance rules. So I think that's all we have for the program. We went a little bit over. But so I think we can, I know we have questions online. I'm sure we have a lot. We will address those after, but if there's anyone here in the room that has any questions, there's a live mic there if you want to step up so it can, for the benefit of everyone participating, please feel free. Don't make it too hard, Josh.
Might be easy. You can say, oh, well, the IRS is doing away with the group exemption, et cetera. But the question I had was with respect to the way that you're describing group exemption and some of the controls that the parent should have, how that interacts with the liability piece where there's the piercing of the corporate veil, because it would seem then if there's more control, lending the ability to do the group exemption, then that then might negate the protections you have under liability.
Right, there's an inherent tension there, right? Because the IRS says if you're going to be under the group exemption, you parent entity need to exert some level of supervision and control. And the concept under common law for piercing the corporate veil is, do you so control the activities, the day-to-day activities of the subordinate that you're effectively the same entity? I can say, practically speaking, the level of control that the IRS would require under group exemption does not rise to the level where it would give a lot of risk under piercing the corporate veil. Do you agree? I mean,
Yeah, no, I agree.
yeah.
Just the multitude of factors and following other corporate formalities can help establish that separateness.
where you see a court pierce the corporate veil and say, okay, well, obligations of chapter and liabilities of chapter become liabilities of parent. It's almost always some aspect of not observing your own corporate formalities, not having a true separate board, not having a true separately incorporated entity. And you know, then even then, like commingling was some plus factors need to be there that obviously you would not have even if you have supervision and control under the group exemption. But that's a balance to be very, you know, mindful of when you go down that route. Okay. Well, thanks everyone. Appreciate your time today. It was good to see everyone in person. Can't wait to see you next month, April 14th. We're going to be talking about the international legal issues for nonprofits and talk a lot about the sanctions that are top of mind for a lot of people. But appreciate your sharing your time with us today and see you next month.
Thank you, everyone.
Thank you, everyone.